So let's continue with the computation of penalties. If the offender shall be in prison, the term of duration of the temporary penalties shall be computed from the day on which the judgment of conviction shall become final. So in this case, the start of computation is from the day on which the judgment of conviction shall have become final. Doon pa lang mag-start yung computation. Okay? If there is now the final judgment. For example, nakulong ka ng you are under detention for 2 years. So, hindi ibig sabihin na yung 2 years na yon, meron ka ng 2 years na na-serve. Because the reference of starting to count the penalty is from the moment of final judgment. Okay? So, if there is now the final judgment, that will be the first day of the computation. So, sir, what about yung 2 years ko? Okay? It will be deducted. It will be deducted, but the start of counting is from the day on which the final judgment of conviction shall become final. If nag-judgment na ang court pero nag-apila ka pa rin, wala pa rin yun. That's still part of preventive imprisonment. But anyway, don't worry, this preventive imprisonment can be deducted. Okay? Can be deducted depending upon the final judgment. Kung ano ang magiging final judgment, so pwede yun na i-deduct. At mayroon tayong rules doon. Kung full term ba ang madideduct or halimbawa 2 years kang nandoon, kung yung 2 years ba maidideduct or yung forfeit nung 2 years or yung na-serve mong sentence. So that's now under Article 28. Okay? Second paragraph, we have, if the offender be not in prison, the term of duration of penalty consisting of deprivation of liberty shall be computed from the day. Okay? So, the computation is from the day that the offender is placed at the disposal of judicial authorities. Okay? So, again, from the day that the offender is placed at the disposal of judicial authorities. Okay? For the enforcement of the penalty. The duration of the other penalty shall be computed only from the day on which the defendants commence to serve his sentence. So, pag hindi siya nakakulong, so pag nakakulong siya, if he is in prison, so ang start of counting is from the day on which the judgment of conviction become final. But if he is not in prison, meaning to say at large, okay, the term starts from the day the offender is placed at the disposal of judicial authorities. So, in other words, from the day na mahuhuli siya. Kaya halimbawa, there's a final judgment. Then after that, wala siya doon. Then, kailangang huliin. So, the start of counting is not from the final judgment, but from the day na siya ay nahuli. Okay? Yan. Next, we have Article 29, period of preventive imprisonment deducted from terms of imprisonment. So, offender who has undergone preventive imprisonment. Yan. When we say preventive imprisonment, nakulong ka pero ongoing pa rin ang trial. In other words, you are still a detained prisoner. Okay? Offender who has undergone preventive imprisonment shall be credited in the service of their sentence consisting of deprivation of liberty with the full term which they have undergone preventive imprisonment. If the detention prisoner agrees voluntarily in writing to abide by the same disciplinary rules imposed upon convicted prisoners, except in following cases. Okay, general rule. Halimbawa, you are being detained. So, when you are under preventive imprisonment, ang maibabawas ay the full-time. When I say full-time, kung gaano ka katagal sa kulungan bago magkaroon ng final judgment, ibabawas yon. Because what's the rule? Okay? the start of counting is from the day of the final judgment. Kung nakapag-serve ka na before the final judgment, ibabawas yun, general rule, full time. Halimbawa, 2 years, di babawas ang 2 years. 5 years, di babawas ang 5 years. Yon. Except, what are the exemption? When they are the recidivists. Okay, if you are recidivist and been convicted previously twice or more times of any crime. So either you are recidivist or reiteration. Recidivist, quasi-recidivist, reiteration, or habitual delinquent. Okay? Hindi ibabawas sa iyo yung full time. Okay? When upon being summoned for the execution of their sentence, they have failed to surrender voluntarily. So, mayroon kang arrest order or arrest warrant but you failed. Okay? You failed to surrender voluntarily, mawawala sa iyo yung deduction na yan. If the detention prisoner does not agree to abide by the same disciplinary rule imposed upon convicted prisoner, he shall be credited in the service of sentence with 4/5 of the time during which he has undergone preventive imprisonment, as amended by RA 6127. Okay. Once again, the general rule. The general rule is, pag detained ka under preventive imprisonment, mababawas sa'yo, pag mayroon ng final judgment, mababawas yung full time na na-serve mo before the final judgment. Provided you agree voluntarily, provided you agree with the rules of that institution or sa prison. Okay, magsasign ka. Okay, magsasign ka na mag-agree ka sa mga rules nila, so makukuha mo yung full-time deduction. Kung 2 years ka nang nag-serve bago ka masentensyahan, then may babawas yon. Kung 5 years, may babawas yon. Okay? Now, if provided you agree, you must agree to get the full term. But if you did not agree, okay, you does not agree. So, you did not agree, ang mababawas lang sa'yo doon sa preventive imprisonment mo ay 4/5. 4/5. So, 4/5 lang ang mababawas. Okay? So, for example, 5 years ka na. 5 years ka nang nakakulong tapos saka lang dumating yung final judgment. 5 years. And you did not agree to abide with the disciplinary rules inside the prison. So, may babawas ba lahat sa'yo yung 5 years? Pag nag-agree ka, yes, may babawas. Nag-agree ka sa rules ng correction prison na yon. Pero pag hindi ka nag-agree, kahit 5 years ka nang nag-serve under preventive detention, ang may babawas lang sa'yo ay 4/5 of that 5 years. For example, so ilang taon ang 4/5 ng 5 years? So 4 years. So instead of 5 years, 4/5 lang. Why? You did not agree. Pero if you agree, full term, lahat ng na-serve mo. But if you did not agree, 4/5 lang. Okay, so that is now the rule under Article 29. Whenever an accused has undergone preventive imprisonment for a period equal to or more than the possible maximum imprisonment of the offense charge to which he is sentenced and his case is not yet terminated, he shall be released immediately. He shall be released immediately without prejudice to the continuation of the trial thereof or the proceeding on appeal, if the same is under review. In case the maximum penalty to which the accused may sentence is dischero, he shall be released, okay, after 30 days of preventive imprisonment. Okay, tandaan natin yon. How is the rule? Kung yung na-detain ay, halimbawa ang parusa ay 6 months. Na-detain siya, umaabot na siya ng 6 months or more. Wala pang desisyon. So anong gagawin? He shall be released. He shall be released immediately. Kasi nga, yung pagkakakulong niya under detention prevention, naabot niya na yung maximum penalty nung parusang ilalaan sa kasong dinidinig pa lang, wala pang desisyon. Ganun na katagal. So, kailangang i-release na siya immediately. Pero, pag ang parusa ay disyero at wala pang desisyon, okay? Ang disyero, wala namang pagkakakulong ito. Okay? The penalty is disyero but no decision yet. So, kailangan i-release yung taong nakakulong after 30 days of preventive imprisonment habang wala pang final decision. So, kung disyero, release yan after 30 days. Hindi siya pwedeng magtagal. Kasi disyero, hindi naman kulong yan. Okay? You are just only banned to go closer or near the person specified. So, that is Article 29. Okay? So, yan. Next, we have, this is in support with the preceding article. Okay, so, sabi nga kanina, full term ang makuha mo pag nag-abide ka or nag-agree ka sa rule. Okay, if you agree with the rule, ang tawag doon, nagkaroon ng detainee's manifestation that he will agree with the rules of the correctional institution. Okay, pero pag hindi siya nag-agree, okay, magkakaroon din siya ng detainee's waiver of manifestation. So, 4/5 lang ang makukuha niya pag ganun. So, pag mayroong detainee's manifestation, that is full-time. Pag mayroong waiver of manifestation, that is just only, okay, 4/5 ang makukuha niya. So next, we have effects of penalties, okay, Article 30. Okay, yan yung Article 30 natin. The effects of penalties of perpetual temporary absolute disqualification. Actually, 31, 32, 33, 34, 35, and other proceedings, sunod-sunod na yan, these are accessory penalties. Actually, hindi mo naman minsan makikita ang accessory penalties, pero automatic yan. Once na binigyan ka ng parusang principal penalty, kasama minsan yan. Yung perpetual or kasama yan sa perpetual or kasama yung accessory penalties. For example, death penalty. O yun, kasama na yan, yung perpetual or temporary absolute disqualification. Okay, so the principal penalties always have the accessory penalties. Okay, kaya nga yung principal, ito yung pagkakakulong. Ano yung mga parang burloloy niya? Yung earrings, ano yung makeup, o yung accessories. So, may dagdag siya na ganyan. So, ito yung mga yan. Okay, so kahit hindi mo makita yan sa penalty. Okay, like for example, parusa is death penalty, reclusion perpetua. Okay, impliedly, mayroon accessory penalty yan. Okay, so Article 31, yan yung perpetual or temporary absolute disqualification. Yung hindi ka na pwedeng pumasok sa public office or maging government employee. Yung mawawalan ka na ng karapatang bumoto. Yan. At saka hindi ka na may elect pag nakakulong ka. Okay? Next, we have kasama yun sa parusa. Disqualification of office or public employment. Yan. So, we have also loss of all rights to retirement pay and other pension. Mawawala rin yun. So, yan mga yan. Okay, disqualified ka na. That is accessory penalty. Okay, so yan. Article 30. Perpetual or temporary absolute disqualification. Sunod-sunod na ito, mga accessory penalties na ito. Okay? So, ang court ang nagbibigay ng mga ito. Pero ang common sa atin ay yung mga imprisonment. Ito yung mga accessory. Principal yung may mga imprisonment. Ano yun na yung mga principal ulit? Yung death penalty, reclusion perpetua, reclusion temporal, prison mayor, prison correctional, arresto mayor, arresto minor. Okay? So ito naman, itong accessory, ito perpetual or temporary absolute disqualification. Yan. Kasama rin dito yung perpetual or temporary special disqualification. So halos parehas lang din. Okay, kaso nga lang ito temporary. Yung una kanina, yung 30 absolute disqualification. Ito temporary special disqualification. Okay? Yan. So, effect of penalties of perpetual or temporary special disqualification to exercise the right of suffrage. Okay, yung karapatan mong magbomoto or maiboto ay temporaring nawawala. Okay? Yan. Next, we have under this disqualification. Pero pag natapos yung kaso mo at wala absuelto, natapos na yung sentence mo, pwede ka na naman. Ganun yan. Okay? So, that is what you call perpetual or temporary special disqualification. What else? We have accessory. We have suspension. Okay, ito naman is suspension. Ayan. So, you will be suspended for public office or provision. Suspendin ka. Like for example, tatanggalan ka ng lisensya, yan. Suspended kang mag-practice or maybe you cannot perform your function. That is suspension. Okay? Yan, suspended from holding public office. Yan, so these are the examples of suspension. Then we have also civil interdiction. Mawawalan ka ng karapatan. Okay? Shall deprive the offender during the time of his sentence the right for, ano yung mga karapatang mawawala? We have there the parental authority, the guardianship, okay? Then, over your persons or property. So, mawawalan ka ng parental authority. Halimbawa, in times of rape. Ni-rape mo ang ni-rape mo is yung anak mo. Yan. O kaya binubugbog mo yung mga anak mo or yung asawa mo, mawawalan ka ng, okay, sa mga anak mo, mawawalan ka ng parental authority. Sa asawa mo, mawawalan ka ng marital authority. And you have also interdicted or prevented to manage your property and the right to dispose that such property. So, yun ang civil interdiction. Mawawalan ka ng karapatan sa anak mo, sa asawa mo, at sa property while you are still serving or you are still at the time of that sentence. Okay? Privation, yan. Parental rights, guardianship over the ward, marital authority, right to manage the property. Yan. Okay? So, nagiging accessory yan. Depende kung ibibigay yan ng korte. Okay? Pwede silang isama. That's accessory penalty. Okay? Effect of bond to keep the peace. Itong bond to keep the peace parang panghahawakan lang naman na you will not do that action again. Hindi mo na sila ititreat. Mga ganon. It shall be the duty of any person sentenced to give bond to keep the peace. Yan. To present two sufficient sureties who shall undertake that such person will not commit the offense so to be prevented, and that in case such offense be committed, they will pay amount determined by the court in the judgment. Otherwise to deposit such amount to the office of the clerk of the court to guarantee said undertaking. So, in the bond to keep the peace, ito parang panghahawakan nila na hindi ka na ulit gagawa ng krimen. So, pwede yan if the court will decide for that they will give you, aside from penalty imposed, aside from imprisonment, they will give you bond to keep the peace. Okay? The court shall determine according to its discretion kung gaano katagal yung bond. Okay? Na hindi ka gagawa ng krimen. Okay? In relation to the bond na binigay mo. Should the person sentenced fail to give the bond as required, he shall be detained for a period which shall in no case exceed 6 months. Kung hindi siya nakapagbayad dun sa bond na hinihingi ng korte, then makukulong siya, okay, but not exceeding 6 months. Yan. If he shall have been prosecuted for a grave or less grave felony, yun. Pag hindi siya nakabayad at ang kaso ay grave or less grave, okay, so hindi siya dapat mag-exceed ng 6 months. So, ang maximum niya, pwede siyang makulong ng 6 months pag hindi siya nakabayad ng bond to keep the peace. If ang parusa niya ay light felony, pwede siyang makulong ng hindi sobrang 30 days. So, yun, magbayad ka na lang para hindi ka makulong for the bond to keep the peace. Pero pag hindi ka makabayad, depende sa nagawa mo, if that is less grave or grave, okay, pwede kang makulong ng hanggang 6 months. Pero pag yan ay light felony, pwede kang magulong ng hanggang 30 days, depending upon the discretion of the court. Okay. So, yan. Next, we have pardon, its effect. Kanina, pinag-aralan natin pardon of the offended party. If it is a pardon by the offended party, ang mangyayari dyan ay mawawala yung civil liability. But if this is a pardon, okay, by the president, then mawawala yung criminal liability. But the pardon shall not work for the restoration of the right to hold public office or the right of suffrage, unless such right be explicitly restored by the term of the pardon. So, once na na-pardon ka, nawala yung criminal liability mo. Pardon by the president ito kanina natapos natin yung pardon by the offended party. So, pardon by the president, okay, mawawala yung criminal liability, but, okay, hindi siya automatic magre-restore. Okay? So, kailangan i-express that they will restore your right to, okay, public office and right to suffrage. A pardon shall not work the restoration of the right to hold public office or the right to suffrage unless such right be expressly restored by the terms of the pardon. So that is Article 36. The effect of pardon, yan. Kailangan para ma-restore yung right mo, it must be expressly restored. Expressly indicated therein in the pardon that they will restore your right to public office as well as right of suffrage. A pardon shall not in no case exempt the culprit from payment of fine or civil liability. Tandaan nyo yun, pag na-pardon ka ng president, kailangan mo pa rin bayaran yung civil liability mo. Ganun din, baliktad, pag sa pardon by the offended party or by the victim, kahit hindi na pinabayaran yung civil liability, kailangan mo pa rin iserve yung criminal liability mo. Okay? So, next, we have yan. So, pardon by the president does not restore the right to public office or suffrage unless they are expressly restored in the pardon. So, what are the limitations to president's pardon to judgment? Can exercise only after final judgment. So, ang pardon, mangyayari lang yan after final judgment. Hindi pwedeng ibigay ang pardon na wala pang judgment. Excited naman pag ganun, di ba? So, hintayin natin magkaroon ng judgment saka ka pwedeng ipardon by the president. Does not extend into cases of impeachment. So, in impeachment, you cannot give pardon. Okay? Does not extend to cases of impeachment. Yan. So, pardon cannot extend to cases of impeachment. Hindi pwedeng mag-pardon if the case is if in cases of impeachment. Okay? Does not extinguish civil liability, only criminal liability. Okay? Yan. Next, we have pardon granted in general term does not include accessory penalties. Yan. So, next, let's proceed to Article 37, cost. Anyway, it's minimal. Sa court na ang nag-determine nito kung ano yung mga babayaran. Okay, so yung fees and indemnities of the proceeding, yan ang cost. Yung babayaran sa kaso, sa korte. Yan, the fees and indemnities, okay, in the course of judicial proceeding, whether the fixed or unalterable amount, yan, determined by law or regulation in force. So, ano yung mga kailangang bayaran? The cost. We have there the fees, yung processing fee, filing fees, yan. Indemnities, so the fees, the indemnities of judicial proceeding. Okay? When we say costs, in other words, we have also covered the expenses of litigation. Okay? Yan. So, In case of acquittal, the costs are de officio, each party bearing its own expense. Pag acquittal, both. Okay? Mind your own. So that is when it comes to costs. Okay? No costs allowed against the Republic of the Philippines until law provides the contrary. Next, we have pecuniary liabilities. So we have here the pecuniary liabilities. The order of payment in case the property of the offender should not be sufficient for the payment of all his pecuniary liabilities, the same shall be met in the following order. Pag hindi kaya ng property mo na bayaran yung mga liabilities mo, so kailangan unahin mo yung mga iba na bayaran. So dapat ano ang unahin? The reparation of the damage caused. Yung halimbawa may na-damage ka sa tao, ng sasakyan niya, o kaya siya, so that can be the reparation of the damage caused. Kailangan yun ang unahin mo, yung nasira mo. Then indemnification of consequential damages. Yung tao hindi nakapagtrabaho. So yung mga sahod niya for that time na hindi siya nakapagtrabaho because of your action. So that is indemnification of consequential damages. Yan. Then the fine. Okay? The fine, yung multa, and the cost of the proceeding. Yung babayaran sa korte, yun ang huli. So, ang una, yung babayaran sa taong naagrabyado, the reparation. Then, yung indemnification ng kanyang consequential damages. And the fine, the cost of the proceedings. So, yan. So, kung ang kaya lang ng property mo yung number 1, yun lang munang unahin. Kung may sobra, at kakayanin din yung number 2, yun din. Kung kaya lahat, yun. This is in case na kulang. Yan yung pagkakasunod-sunod. Okay, next, we have subsidiary penalty. Now, kung hindi kayang, if the convict has no property with which to meet the fine mentioned in paragraph 3 of this next presiding article. Okay, so ito is next. Okay, next presiding article. He shall be subject to subsidiary personal liability at the rate of 1 day for each 8 pesos. So, 1 day at 8 pesos. Pero, ito, nabago na. Okay, hindi na siya 8 pesos ngayon. Dati, 8 pesos lang. Pero ngayon, hindi na. Okay, so, ang 1 day, ang equivalent niya dati 8 pesos, ngayon hindi na. 1 day, equivalent 40. Ilan ang bawas pag nag-serve ka ng 1 day? Kung in case of subsidiary penalty, okay? So it depends upon the highest minimum wage in the country. The highest minimum wage. O, halimbawa, if in Manila 600 ang highest minimum wage, so ang susundin natin under subsidiary penalty is the highest minimum wage. Kung 600, the 1 day is equal to 600 pesos. But we have rules. Okay, so if the penalty imposed be prisión correccional, okay, 6 years and below. Prisión correccional, aristo and fine. Okay, so ibig sabihin, this is 6 years. 6 years. So, 6 years and below. Yan. Ang parusa ay 6 years and below. He shall remain under confinement until his fine referred to in the preceding paragraph is satisfied. But his subsidiary imprisonment shall not exceed 1/3 of the term of his sentence. Okay, so dapat hindi siya susubra. Shall not exceed 1/3 of the term of the service. And in no case shall continue for more than 1 year. So, if the penalty is 6 years and below, kailangan hindi yan lalampas ng 1 year ang kanyang subsidiary imprisonment. Okay? shall not continue. Okay, in no case shall not continue for more than 1 year. So, hindi dapat. Okay? And no fraction of part of a day shall be counted against the prisoner. So, hindi lalampas ng 1 year ang subsidiary imprisonment pag 6 years and below ang parusa or hindi lalampas sa 1/3 ng kanyang parusa. Okay? Next, we have whenever the principal penalty is only a fine. Okay? Kung ang parusa ay fine, the subsidiary imprisonment shall not exceed 6 months. So, pag yan ay fine, shall not exceed 6 months. Okay? If the culprit shall have been prosecuted for a grave, less grave felony and shall not exceed 15 days. If for light felony. Okay? Pag light felony naman, shall not exceed 15 days ang kanyang subsidiary imprisonment. Okay, kung fine lang. And for light felony, hindi lalampas ng 15 days. Pero pag grave and less grave at fine lang, then kailangan hindi lalagpas ng 6 months. Okay, so not exceed 15 days, not exceed 6 months. Okay, pag yan ay grave or less grave, not exceed 6 months. If yan ay light felony, not exceed 15 days. If we are only talking about yan, fine. Okay, next we have when the principal is higher than prison correctional. Okay, kung yan ay more than 6 years. Okay, more than 6 years. If that is more than 6 years, no subsidiary imprisonment. Kung yan ay prison mayor, reclusion temporal, reclusion perpetua, no subsidiary imprisonment. In other words, subsidiary imprisonment is applicable only if the penalty is 6 years and below. If more than 6 years, no subsidiary imprisonment. If the principal penalty imposed is not to be executed by confinement in a penal institution, but such penalty is of fixed duration, the convict during the period of time established in the presiding rules shall continue to suffer the same deprivation as those of which the principal penalty consists. The subsidiary personal liability which the convict may have suffered by reason of insolvency. Okay, bakit ka kasi dadagdagan? Bakit may subsidiary imprisonment? Kasi hindi ka makabayad ng fine mo. Okay, shall not relieve him from the fine in case his financial circumstance should improve. Pero in case your financial circumstances improve, babayaran mo pa rin yung subsidiary penalty mo. So that is Article 39, subsidiary penalty. Next, we have debt. It's accessory. O yan. So yung debt, ang accessory niya, dinidefine lang dito, gaya ng perpetual, absolute, disqualification. Yan. So, andyan yung mga disqualification niya. Accessory penalty niya, rather. Plus civil interdiction. Okay? So, ito yung mga pwedeng isama sa debt na accessory penalty. Sa reclusion perpetua temporal naman, okay? Ano ang pwedeng isama ang accessory penalty? Okay, their accessory penalties is civil interdiction. Yan yung pwedeng isama. Civil interdiction. Okay? Yan. Or absolute, perpetual absolute, disqualification, pwede ring isama yan as accessory penalty. Okay? So yan yung mga accessory penalty natin na pwedeng isama sa reclusion perpetua and temporal. Okay, for prison mayor, ano naman ang pwedeng accessory penalty ng prison mayor? Okay, temporary absolute disqualification. Yan, and perpetual special disqualification. Okay, from rights to suffrage. Okay, so yan, yung mga pwedeng isama sa presyon mayor. Presyon correctional. Ano naman yung pwede nating isamang accessory penalty? Okay? Suspension. Pwedeng isama yan sa presyon correctional. Okay? Perpetual special disqualification for right to suffrage. Pwede rin. Okay? Yan. So, yan yung mga pwede ring isama under presyon correctional. Aresto, either aresto mayor or aresto minor. Okay, pwedeng suspension ang kasama na accessory. So, yan yung relationship ng principal penalty and accessory. Pwedeng isama yan sa kanila. Confiscation and forfeiture of the proceeds of instrument of crime. Ano ang gagawin sa mga gamit, pera o mga ari-arian na naging bunga ng krimen? Okay? Or galing sa krimen. So, they must be forfeited. Every penalty imposed for the commission of a felony shall carry with it the forfeiture. Okay? They will be forfeited. Forfeiture of the proceeds of the crime and the instrument or tools in relation to the crime. So, such instrument or tools or this object, property, mga yan, and others will be forfeited in favor of the government. They are forfeited in favor of the government. Halimbawa, yung ginamit nyong ride-away car, yung pera during yung ginamit sa pagbili ng drugs, yung mansyon na galing sa wedding, they will be forfeited in favor of the government. Yan. At yung mga iba pang galing sa krimen. Unless yung property na yon ay pagmamay-ari ng third person, not liable for the offense. Unless the property owned by third person, not liable of the offense. Pero kailangan i-prove na niya. Okay? So, yan. So, yung mga illegal naman na object na nakuha, like drugs, mga yan, or kaya pirated CD, they will be subjected for destruction. Sisirain yan. Mga drugs susunugin, yung CD is sisirain, mga yan. Okay? O yung mga gambling machine, yung mga anong tawag mo doon, yung mga ginagamit for gambling na machine, so pwedeng sirain yon. But others, like money, like house, buildings, mga yan, or vehicles, they will be forfeited in favor of the government. Next, we have penalty to be imposed upon principal in general. So, the penalty prescribed by law for the commission of the felony shall be imposed upon the principal in the commission of the felony. So, we have Article 46, yan, 50, 51, 52, 53, 54, 55, 56, 57. So, ito, mayroon tayong isang illustration mamaya. Ang ibig sabihin lang ng Article 46, pag ikaw ay principal, okay? Pag ikaw ay principal at consummated yung krimen, nagawa nyo yung krimen, ang ibibigay na parusa sa iyo ay yung nakalagay na parusa sa batas. Walang dagdag, walang bawas. Yun yung general rule. The penalty prescribed by law. If you are the principal and you consummated the crime. So, the penalty must be what is being prescribed by the law. So that is Article 46. Yan. Whenever the law prescribe a penalty for a felony is general term, it shall be understood as applicable to consummated felony. So yun yun. So when we say you are the principal plus what is committed is consummated, then ano ang parusa? The penalty prescribed by law. Walang dagdag, walang bawas. Unless mayroong aggravating at mayroong mitigating. Okay? So, next we have yan. So, ito ang ibig sabihin ng Article 46. Kung ikaw ay principal and yan ay consummated, okay? Ikaw ay principal and that is consummated, okay? Wala pong dagdag ang parusa. Ay walang bawas ang parusa. As is, kung ano ang parusa, yun ang ibibigay sa'yo. For example, you committed the crime of murder. Ang parusa ay reclusion perpetua. The penalty is reclusion perpetua. You are a principal. At the same time, you are a principal. So, principal ka. Yan. At the same time, you consummated. So, ang susundin is yung parusa na binigay ng batas kasi principal ka at consummated, ang parusa mo ay reclusion perpetua. Now, under Article 50, kung ikaw ay principal, okay, ikaw ay principal, pero yun ay prostrated. Ikaw ay principal, pero ang nagawa mo ay prostrated, may bawas kang isa. May bawas kang isa sa original na parusa. Okay? So, let's say ang original na parusa dito ay reclusion perpetua. Yan, reclusion perpetua. Oh. Kung ikaw ay principal, at yan ay consummated, walang bawas, so reclusion perpetua ang ibibigay. Pag ikaw ay principal, tapos prostrated, babawasan ng isa. So, bababa ng isa ang reclusion perpetua, magiging reclusion temporal. Okay, that's Article 50. Pag ikaw ay, okay, let's proceed with Article 51. Pag ikaw ay principal, tapos ang nagawa nyo ay attempted. Okay, principal at nagawa nyo ay attempted, yan. So, babawasan yan ng dalawa. So, from reclusion perpetua, bawas ka ng dalawa, bababa ka, okay, is pagbaba niyan is temporal, tapos presyon mayor yung pangalawa. So, ang magiging parusa mo pag principal at attempted with yung original natin na penalty na reclusion perpetua, bababa na lang siya ng presyon mayor kasi bumaba ng dalawa. Okay? That's Article 51. Article 52. Ikaw ay accomplice. You are accomplice. Okay? You are accomplice and the crime is consummated. You are accomplice and the crime is consummated. Yan. Accomplice ka, ang krimen consummated, babawasan ka ng isa. Babawasan ka ng isa from the original sentence. So, ilan ang bawas? Bababa ka ng isa from reclusion perpetua, magiging reclusion temporal. Kasi nga, ikaw ay accessory lamang. Okay? Next, we have, ikaw ay accomplice lamang. Kaya bababa ng isa kung consummated. Pag ikaw naman ay accessory, under Article 53, accessories ka. Tapos, the crime you committed is consummated. So, consummated din yung nagawang krimen. So, consummated. Okay? Accessories and consummated, okay? Bababa ka sa dalawa. So, bababa ng dalawa. From the original sentence. So, ang original natin, reclusion perpetua for example. So, bababa ng dalawa, ang parusa mo magiging presyon mayor. Presyon mayor na lang. So, anong na-observe mo? Okay. As you can observe on these boxes, yan, ano? Pag ikaw ay principal at yan ay consummated, then yung original na parusa, yun ang parusa mo. Pero pag ikaw ay accomplice at na-consummate nyo, bababa ka ng isa. Kaya mas mababa ang parusa mo sa principal. Pag ikaw ay accessory, bababa ka ng 2. So, mas mababa ang parusa mo kaysa sa principal at accomplice. Ganun yon. Okay? Now, let's proceed with Article 54. Yan. Under Article 54, pag ikaw ay accomplice, okay, you are accomplice, at ang nagawa mo ay prostrated, that is accomplice, and naging prostrated yung nagawa nyo, okay, may bawas kang 2. So, bawasan natin yung original sentence, reclusion perpetua, bababa ng 2 level, magiging prisyon mayor. Magiging prisyon mayor. Yan. Pero pag ikaw ay accessory, okay, ikaw ay accessory at ang nagawa nyo ay, again, ang nagawa nyo ay prostrated. Yan. So, pag nagawa nyo prostrated, accessory ka, babawasan ka ng 3. So, babawasan ka ng 3 from the original sentence na perpetua. So, babawasan ng 3, bababa ka na lang, ang parusa mo ay prisyon correctional. Prisyon correctional. Okay, that is Article 55. Under Article 56 naman, okay, pag ikaw ay accomplice, okay, you are accomplice, tapos, ang nagawa nyo ay, okay, attempted. Okay, you are accomplice at saka attempted, may bawas yan na 3. Okay, bawas in reference dun sa original sentence, bababa tayo ng 3 sa perpetua. So, magiging prisyon correctional na lang. Okay, prisyon correctional na lang. Article 57, you are accessories. Okay, accessories pero ang nagawa nyo ay attempted. Okay, accessories attempted, may bawas kang 4. Okay, so bawasan natin from original sentence, bawasan natin ng 4. So magiging, okay, aristo mayor. Aristo mayor. So it covers your 46 to 57. Okay, so nakita nyo yung parusa magkaiba sa principal, accomplice, and accessory. Ganun din. In terms of principal, tignan natin in terms of principal. Okay? Pag ang nagawa niya consummated, yung original. Pero pag ang nagawa niya prostrated, bababa ng 1. Pag ang nagawa niya ay attempted, bababa siya ng 2. So, yun ang implications dito. So, just memorize the box and you will now, you discuss already Article 46, 50, 51, 52, 53, 54, 55, 56, 57. 1 box in 9 articles. Yan lang ang ibig sabihin nun. Okay? Next, we have, in what cases the death penalty shall not be imposed? The death penalty shall be imposed in all cases in which it must be imposed under existing law. But Article 47, wala na ito because of RA, okay, because of RA 9344. So, because of RA 9344, okay, wala na po 9346 rather, because of RA 9346, wala na po tayong death penalty. But for the sake na pasadaan lang natin, okay, yung ano ba yung in case na may death penalty, ano yung mga hindi pwedeng ipasok sa parusang death penalty. If he is more than 70 years old, i-commute na yan. Okay? So, yung lahat, all the members are not unanimous. Yung Supreme Court judges are not unanimous in their voting, so the death penalty cannot be imposed. So yun. And we have penalty for complex crime. So what about complex crime? When a single act constitutes two or more grave offense, or when the offense is necessary means for committing the other. Again, a single act constitute two or more offense. Isang action, dalawa at tatlo or dalawa or mas marami ang nagawang parusa. Okay? Or an offense is necessary. Yung offense na yan is necessary in committing the other. So yan yung complex crime natin. Okay? The same be applied in its maximum period. So maximum pag complex crime, ano? Yan. So mayroon tayong tinatawag na kinds of complex crime. The compound crime or delito compuesto. Okay? And that only one single act is constituted by the offender, that the single act produces two or more grave. So in delito compuesto, compound crime, we have one act is to 2 or more. Isang action, dalawa or mas maraming krimen ang nangyari. Binaril mo si A, tinamaan si A, tumagos kay B, kay C, kay D. So if that will be the case, that is an example of compound crime. Delito compuesto, single act constitute two or more grave or less grave felonies. Okay? Yan. That is one act, two or more. 1:2. Okay? Next, we have the number 2. We have there the complex crime proper. Yung tinatawag nating delito complejo. When the offense is necessary means for committing another. Okay? So, kailangan dito 2 crimes, 2 acts. 2 acts na mukhang parang dalawang krimen pero actually iisa lang ang nangyaring krimen. Kung yung una kanina, one single act produces 2 crimes or felonies, grave or less grave felonies, that is compound crime. 2 acts in order to commit one crime or offense, that is complex crime proper. Delito complejo. Okay? Yan. So, paano ito? Halimbawa, may gusto kang patayin na tao. Now, you want to use fire. Alam mong nasa kubo siya. But your intention is to kill the person. Now, para mas walang ebidensyang makuha, sinunog mo yung kubo na nandun siya. Or sinunog mo yung bahay niya kung asan siya. Okay? So, namatay yung tao. The crime is murder. Okay? So, wala na po yung arson. Because arson is just only a means. The fire is only a means for you to, okay, kill the person. So, parang mayroong ng kasong arson kasi sinunog mo yung bahay. Pero ang purpose mo, ginawa mo yun para patayin yung tao. So, it will become murder and not arson with murder. Wala po yun. So, murder na lang po yun. Okay, so that is what you call complex crime proper. Okay, so yun ang pagkakaiba ng dalawa. Pero pag pinagsama mo ito, compound crime at saka complex crime proper, ang tawag talaga nila dyan ay, okay, they are called, ang tawag nila dyan ay, okay, they called it as complex crime. Yan yung complex crime. And there are also 2 other types of complex crime, the what you call continued crime or delito continuado or yung single larceny, theft. And the number 4 is continuing crime. We have there the continuing crime. So, aside from compound crime, complex crime proper, we have continued crime and continuing crime. Paano yung continued crime? Continued crime delito continuado, meaning a single criminal resolution happened in the same place at the same time, committed by the same persons. So, isang grupo, gusto nyong i-rob out or gusto nyong i-rob yung isang stall or isang compound, rather. Tapos may 5 bahay. 5 rin kayo. Tiki-isa kayong isa-isa yung pinasok ninyo. Tapos sabay na pumasok, then sabay na sumakay sa sasakyan. Okay? Hindi po iba-iba ang kaso ninyo kung nagnakaw kayo. That is one single act of robbery. Kahit iba-iba yung pinasok ninyo. Because you have a single criminal resolution. Continued crime or delito continuado. Single larceny theft. Continuing crime, it happens on different places. Like rebellion. Rebellion, for example, rebelde ka sa Pangasinan, rebelde ka sa Tarlac, naging rebelde ka sa Baguio, naging rebelde ka sa Pampanga, or naging rebelde ka sa Maynila, or pumunta ka pa ng Visayas, or even Mindanao. So, ang dami mong pinuntahan. So, ibig sabihin, sir, iba-iba ba yung kaso kung saan-saan siya nagpunta? Hindi. There is only one crime of rebellion kahit kung saan-saan siya pumunta. Because that is a continuing crime. That although it happens in different places, there is only one crime to be filed. That is continuing crime. Okay, next, we have penalty to be imposed upon principal when the crime committed is different from what is intended. Okay, ito yung tinatawag nating praeter, So, this called praeter intentionem. So, ang tawag dito ay praeter intentionem. Okay, yung iba ang nangyari sa inaasahan mo. Penalty to be imposed upon the principal when the crime committed is different from what is intended. Okay, in case in which the penalty committed is different from what which the offender intended to commit, the following rule shall be observed. The penalty prescribed for the felony committed be higher than the corresponding to the offense which the accused intended to commit. The penalty correspond to the latter shall be imposed in its maximum. Okay? So, anong ibig sabihin? So, the penalty prescribed for the felony committed is higher. Okay? So, mas mataas ang parusa nung nagawa niya kaysa sa gusto niyang gawin. Okay? Ang ibibigay na parusa ay yung parusa ng gusto niyang gawin pero maximum period. Yun ang paragraph number 1. Number 2, if the penalty prescribed for the felony committed be lower, o mas mababa yung nagawa niya ay yung parusa nung nagawa niya kaysa sa gusto niyang i-commit. Okay? The penalty for the former shall be imposed to its maximum. Ang susundin naman yung lower. Pero it must be in maximum period. Yan. So parang pabor na pabor sa akusado ang article na to. The rule established by the next preceding paragraph shall not be applicable if the acts committed by the guilty person shall also constitute attempted or frustrated or another crime. If the law prescribe a higher penalty for either of the latter offense, in which case the penalty provided for the attempted and frustrated shall be imposed in its maximum period. So yun lang ang Article 49. Kung ang parusa ng nagawa niya ay mas mataas kumpara sa gusto niyang gawin, ang masusunod yung parusa ng gusto niyang gawin pero maximum. Kung ang parusa ng nagawa niya ay mas mababa kaysa sa gusto niyang gawin, ang masusunod ay yung mas mababa pero nasa maximum. Okay? And sa paragraph number 3, unless may batas na nagsasabi na ang parusa talaga ay ganon, yung batas susundin kung specified yung parusang ibinigay. Okay? Article 50, lampasan na natin to. Diniscuss na natin ito sa may VAX. 50, 51, 52, 53, hanggang 57. They are being covered by your VAX. Yung pinakita natin kanina. Okay? Now, let's proceed with Article The difference between degree and period muna tayo. So yung degree refers the penalty imposed for a felony committed considering the stages of execution and the degree of participation of the offender. Pag period, the duration of the penalty consisting of maximum, medium, and minimum. So pag sinabi nating degree, yan yung reclusion perpetua. Okay? Tapos, susunod na degree, reclusion temporal. Yan. Then, susunod na degree, we have prison mayor. Yan. Prison mayor. O yan, yun yung mga degree. Pero pag period, halimbawa, reclusion temporal, hatiin natin yan into period. Okay? So, reclusion temporal, we have there the maximum. Okay? So, yan yung mga period na tinatawag natin. Maximum ng reclusion temporal. We have also the medium. Okay? Mayroon tayong medium. And also, we have there the minimum. Yan yung tinatawag nating period. Okay? So, the maximum, medium, and minimum. So, these are the difference between degree and period. Okay, Article 58, additional penalty to be imposed upon certain accessories. Yan. Those accessories falling with the term of paragraph 3, Article 19 of this code, who should act with abuse of their public function shall suffer the additional absolutory. O yan. So, Article 50 only discuss about ano yung idadagdag if the principal is guilty of the grave offense under Article 19, paragraph number 3. Okay, yung accessories who conceal. Okay, so aside sa parusa nila, bilang accessory, mayroon additional na absolute perpetual disqualification pag ang nagawang kaso ay grave felony. Pero pag least grave, okay, absolute temporary disqualification lang. Okay, yan yung rule. So, siyempre accessory penalty may bawas 'yon, di ba? Depende sa kaso. So, aside from sa kalalabasan, pag binawasan na, dadagdagan pa siya ng absolute perpetual disqualification kung yun ay grave felony at saka absolute temporary disqualification kung yun ay less grave felony. So yan. Okay, so that's Article 58. Next, we have 59, penalty to be imposed in case of failure to commit the crime because the means employed or the means sought are impossible. This is in times of impossible crime na pinag-usapan natin. So impossible crime. When you say impossible crime, we cannot perform the crime because of its inherent impossibility. Because of ineffectual or inadequate means. Pero kahit magkaganon man, may parusa pa rin ang impossible crime. The penalty is aristo mayor and a fine of 200 to 500 pesos. What is being punished in this is the criminal propensity or the criminal tendency. Okay? Kaya mayroon ka pa ring parusa dito sa Article 59 na ito. Okay? So, yan. The social danger and degree of criminality or the criminal propensity or criminal tendency. Yan. The criminal propensity or the criminal tendency. Yan. So, ito yung mga reasons bakit ka paparusahan even though impossible crime. Malala nyo yun, yung ninakaw mo yung sarili mong nagnakaw ka, di mo alam na wallet mo pala yun, yung nanakaw mo kasi ninakawan ka rin dati, or relo mo pala yung nanakaw mo. O kaya pinatay mo yung tao, gusto mong patayin yung tao pero patay na pala. Yan, so these are. And take note, the impossible crime is again, crime only applicable to crimes against person and property. Next, exemption to the rule established in Article 50 to 57. The provision contained Article 50 to 57 inclusive of this code shall not applicable in cases which the law expressly prescribe the penalty provided for a frustrated and attempted felony or to be imposed upon accomplice or accessory. So, as you can observe in Article 46, or 46 to 50, 51, 52, 53, yung sa box kanina, 54, 5, 55, 56, 57, yung sa box na pinag-aralan natin, yung may mga bawas, hindi po yun. Under Article 60, sabi niya, hindi yun applicable. Okay? Kung mayroong batas, law expressly prescribe the penalty. General rule, it is applicable, but if there is a law expressly prescribe the penalty, especially about frustrated and attempted, and accomplice and accessory, hindi na po applicable ang Article 50 to 57. Pero pag wala naman nagsasabing batas, yun pa rin ang masusunod. The Article 50 to 57, including the 46. Rules for graduating penalties. For purpose of graduating the penalties, which according to the provision of Article 50 to 57, okay, inclusive of this code are to be imposed upon person guilty of principal of any frustrated. So, yun na, yung pagkakasunod-sunod. Yan. When the penalty prescribed for the felony is single and indivisible, the penalty next lower, the degree shall be the immediate following the indivisible penalty. Halimbawa, capital debt. Okay, so hindi mo walang indivisible naman ang debt. So, ang susunod doon ay reclusion perpetua. Pag reclusion perpetua, ang susunod naman doon ay reclusion temporal. Yun. When the penalty prescribed to the crime is composed of two indivisible penalties or of one or more divisible penalties to be imposed to their full extent, the penalty next lower in degree shall be the immediate following the lesser of the penalty prescribed in the respected graduated scale. So, the penalty of, sabihin niyang, maximum reclusion, let's say, reclusion perpetua maximum, ganon, reclusion temporal maximum to reclusion perpetua minimum, ganon. So, ang reference natin dun sa pagbaba is yung reclusion temporal maximum. So, pag bababa siya ng 1 degree lower, magiging prison mayor maximum. So, we will refer yung pagbaba doon sa, okay, lesser penalties prescribed. So, reclusion temporal maximum to reclusion perpetua minimum. So, ang mas mababa doon yung reclusion temporal maximum. So, pagbababa ng isa, magiging prison mayor maximum. Kasi, yun yung, ang reference natin yung mas mababa. Kung yan ay dalawang period. Dalawang degree. Yung temporal to perpetua, sabi niya. So, reclusion temporal maximum, reclusion to reclusion perpetua minimum. So, ang mababa doon yung temporal. So, yung temporal ang reference natin para tayo ay bumaba sa pagbaba niya. Okay? When the penalty prescribed for the crime is composed of one or two indivisible penalties and the maximum period of another divisible penalties, the penalty next lower in degree shall be composed of medium and minimum period of the proper divisible penalty. Anyway, this divisibility, court nang nagsasabi naman yan, so we can pass it track, just read. When the penalty prescribed for the crime is composed of several periods corresponding to different indivisible penalties, the penalty next lower in degree shall be composed of period immediately preceding the minimum prescribed and the two next following which shall be taken from the period prescribed. If possible, otherwise from the penalty immediately following the above mentioned respected graduated scale. When the law prescribes a penalty for a crime in some manner not specifically provided in the four preceding rules, the court, proceeding by analogy, shall impose corresponding penalties upon those guilty of principal of frustrated and attempted the same, and upon accomplice and accessory. So that is under our Rule 61. Here are the rules on graduating penalty. Baba. Next, effect of the attendance of mitigating and aggravating and habitual delinquency. Again, mitigating and aggravating and habitual shall be taken into account for the purpose of diminishing or increasing the penalty in conformity with the following rules. Yan. Aggravating, which in themselves constitute a crime especially punishable by law, or which are included by the law in defining the crime and prescribing the penalty, shall not be taken into account for the purpose of increasing the penalty. Yan yung sinasabi nating qualifying and inherent. Pag yan ay qualifying and inherent aggravating circumstances, because they are already constituting a crime or they are part of the element, then no, they shall not be taken into account for increasing the penalty. Hindi na po natin gagamitin kasi elements na sila ng krimen. Okay? It qualifies or it is already inherent. The same rule shall apply with respect to any aggravating circumstance inherent. So this is qualifying, this is inherent. Yan. So ganun din. We should not take account. So wag na nating i-consider yon para dagdagan yung parusa kasi kasama na siya sa elements. Aggravating or mitigating which arise from moral attribute of the offender or from his private relations with the offended party or from other personal cause shall only serve to aggravate or mitigate the liability of the principal, accomplice, and accessory as to whom circumstances are attendant. So, kung sino lang sa kanila ang pwedeng i-apply yon, so meaning to say, hindi pwedeng i-apply kung maraming accused. Halimbawa, relationship. Sino lang ang relatives niya, doon lang pwedeng i-apply. Ganun yan. Halimbawa, 3 ang accused. Isa doon relative. So yun, pwedeng ipasok yon. Yung sa relatives lang. Pwede siyang ma-mitigate or ma-aggravate. Okay, so yan yung example nun. Number 3. The circumstances which consist in the material execution of the act or in the means employed to accomplish it shall serve to aggravate and mitigate the liability of those persons who had knowledge of them at the time, okay, of the execution of the act or their cooperation. Okay, so the circumstance which consists in the material execution of the act or in the means employed to accomplish it, okay, shall only aggravate or mitigate, okay, kung yung tao alam niya, okay, had knowledge of the crime on the time the execution of the act or they are part of this. Pero pag hindi niya alam, hindi pwedeng i-apply sa kanya ang aggravating and mitigating. Okay, habitual delinquency shall have the following effect. Okay? Upon a third, pag habitual delinquency naman, habitual delinquency yung within 10 years. Okay, within 10 years, you committed 3 times or oftener. Yung falsification, robbery, estafa, theft, serious physical injury, and less serious physical injury. Yan. So upon a third conviction of the culprit, shall sentence the penalty provided by law for the last crime of which he was found guilty. So pag ikaw ay habitual delinquent at pangatlong beses na yon, mayroon kang additional penalty na prisyon correctional in its medium and maximum period. Prisyon correctional. So aside sa parusa mo sa 3, mayroon kang additional na prisyon correctional, okay, and its medium and maximum period. In its medium and maximum period. Pag yan ay pang-4 na, okay, meron kang additional penalty na prisyon mayor in its minimum and medium period. Pang-4 mo na, may dagdag pa yan na penalty. Okay? So, prisyon mayor in its minimum and medium period. Again, pag pangatlo, prisyon correctional in its medium and maximum period. Pang-4, prisyon mayor in its minimum and medium period. Pang-5, okay, upon 5th or additional conviction, yan, 5th or more, so ang parusa mo na may dagdag yan na, aside sa mga parusa mo, may dagdag na presyon mayor in its maximum period to reclusion temporal in its minimum period. So yan yung mga aside sa parusa mo na binigay kasi ang dami mo ng kaso and you are habitual delinquent, mayroon pa tayong additional. Kung pangatlo, mayroon kang presyon correctional in its medium and maximum period. Kung pang-apat, mayroon kang presyon mayor in its minimum and medium period. Kung panglima or mas marami pa, presyon mayor in its maximum and to reclusion perpetua, reclusion temporal. Presyon mayor in its maximum period to reclusion temporal in its minimum period. Okay. Yan. Notwithstanding the provision of this article, the total of two penalties to be imposed upon offender in conformity shall not exceed 30 years. Okay? Shall not exceed 30 years. Yan. For the purpose of this article, a person shall be deemed be habitual, yan, if within period of 10 years from the date of release, conviction, serious physical injury, less serious physical injury, rubo. Rubo means robbery. Hurto means theft. Yan, estapa and falsification is found guilty of the crimes a third time or oftener. Yan yung tinatawag nating pretzel. Okay? Next, we have Article 63, the rules for the application of indivisible penalties. In all cases in which the law prescribes a single indivisible penalty, it shall be applied by the court regardless of any mitigating or aggravating circumstances attended. Okay, so yun. So, the court will apply if that is single indivisible. If that is single indivisible, yan, the court shall apply regardless of mitigating or aggravating circumstances. Like, ano ba yung single indivisible? The death penalty and the reclusion perpetua. In all cases in which the law prescribes a penalty composed of two indivisible penalties, the following rule shall observe. Anyway, yan, when the commission of the deed, there is present only one aggravating and greater penalty shall be applied. So ito na yung dagdag bawas, ano? Okay, so now, if mayroong isang aggravating, so yung mas mataas ang, halimbawa, we have there the reclusion temporal maximum to reclusion perpetua minimum. Okay, doon tayo sa maximum, sa kanya, pinakamas mataas. Reclusion perpetua minimum. In case of two indivisible penalties. Okay, yan. When there are neither mitigating nor aggravating and there is no aggravating circumstance, the lesser penalty shall be applied. When there are neither, okay, merong mitigating nor aggravating, okay, pero wala siyang, okay, when there is mitigating, ganito na lang, when there are neither mitigating nor aggravating, walang mitigating, walang aggravating, and there is no aggravating, the lesser penalty shall be applied. So kung walang aggravating, okay, halimbawa kanina dito, we have reclusion temporal minimum ay maximum and reclusion perpetua minimum. So kung may aggravating, okay, yung nasa reclusion perpetua ang susundin. Kung walang aggravating, okay, ang susundin ay yung si reclusion temporal maximum. Yan. When the commission of the act is attended by some mitigating circumstance and there is no aggravating, the lesser penalty shall be applied. So, ganun din. Okay? Mayroong mitigating, so yung mas mababa ang i-apply natin. When both mitigating and aggravating attended the commission of the act, the court shall reasonably allow the offset So, may mitigating, may aggravating. So, kailangan i-offset, minus. So, wala. Which? Provided ang present na mitigating ay ordinary mitigating, hindi privilege. Kasi ang privilege, hindi pwedeng i-offset sa aggravating. Okay? Next, rules for the application of penalties which contains 3 period. In case in which the penalty prescribed by law contains 3 period, yan yung maximum, medium, minimum. Whether it be a single divisible penalty or composed of 3 different penalties, each one of which form a period in accordance with the provision of 76 and 77, the court shall observe the application of penalty, the following rules, according to whether they are or are not mitigating or aggravating. When there are neither aggravating nor mitigating, they shall impose the penalty prescribed by law. Kung walang mitigating and aggravating, kung ano ang parusang inigay ng batas, yun ang ibibigay na parusa. Okay? When only one mitigating is present of the act, okay? Kung isa lang na mitigating, okay? Kung isa lang ang mitigating, for example, we have here the reclusion temporal, okay? So, na-divide siya into tatlo. The maximum, yan. So, we have here the maximum. Then, sa gitna, usually, we are using the medium. Yan. So, we have there the medium. Then, the last, we have there yung pinakamababa, the minimum. Yan. So, for example, kung iisa lang ang mitigating, so ang parusa will be the minimum. Yan. Kung isa ang mitigating, ha? Kung isa ang mitigating, doon tayo sa minimum. Okay? Next, when the aggravating is present, they shall impose maximum. Pag present naman ang aggravating, so doon naman siya sa maximum. Pag present ang aggravating, isang aggravating, walang mitigating, maximum. Pag isang mitigating, walang aggravating, minimum. Okay? Pero pag wala, parehas na wala. Okay? Pag parehas na wala, it will be on the medium. So, pag parehas na wala, doon ka sa medium. Okay? When both mitigating and aggravating circumstance are present, the court shall offset. So, ganun din. Both mitigating and aggravating circumstance present, offset. Pagbawasin mo sila. Which mo sila. Lalo pag sinasabi nating ordinary mitigating lang yon. When there are two or more mitigating, okay, circumstance and no aggravating are present, the court shall impose a penalty next lower to the prescribed by law in the period that it made them applicable according to the number and nature of such circumstances. So, with our example, we have reclusion temporal. Susunod is prison mayor. Yan. So, we have prison mayor. Ganun din. We have there the maximum. Okay. We have there the maximum. Yan. And we have also there the medium. Okay, we have there the medium and we have there the minimum. Okay, so yan. Okay. So, sabi niyo dito sa article 5, sa number 5, kung marami kang mitigating, halimbawa, nag-start tayo sa medium. Mayroon tayong mitigating na dalawa, isa, dalawa. Okay, hanggang dyan. Kung tatlo, hanggang doon. Okay? Kung apat, hanggang dito sa minimum ng prison mayor na. Kung hanggang 5, di bababa ka pa rin. So yan, bababa ka hanggang pwedeng bumaba. Yun ang sa rule sa mitigating. Okay? Pero pagdating sa aggravating, whatever may be the number or nature of aggravating circumstance, the court may not impose greater penalty than that prescribed by law. Okay? Not impose greater penalty than that prescribed by law in its maximum period. Halimbawa, ang parusa ay prison mayor medium. Prison mayor medium. For example, the penalty is prison mayor medium. Okay? So, mayroong tatlong aggravating. So, tataas ka. 1 Pero hanggang dito ka lang. 2, yan, hanggang maximum ka lang. So, you will end here. You will end here. Hindi ka pwedeng pumunta sa ibang degree. Yan. So, parang unfair, no? Ang mitigating, pwede kang bumaba hanggang sa pinakamababa. Pero ang aggravating, hanggang sa maximum lang ng period na yon. Hindi ka pwedeng mag-include sa ibang, hanggang sa maximum lang ng degree na yon. Kung presyon mayor, hanggang sa maximum lang niya. Hindi ka pwedeng pumunta sa reclusion temporal. Pero pag mitigating ang marami, galing ka ng temporal, pwede kang bumaba hanggang maabot mo nga ang aresto mayor o aresto minor, pwede pa rin yon. So, ganun siya ang pagbaba niya. Okay? That is now the rule on the application of penalties which contains 3 period. Yan. Within the limits of this period, the court shall determine the extent of penalty according to the number and nature of aggravating, mitigating circumstances, and the greater and less extent of the evil produced to the crime. Next, we have rules in case in which the penalty not composed of 3 period. In case in which the penalty prescribed by law is not composed of 3 period, the court shall apply the rules contained in the foregoing article, dividing them into 3. So, pag walang period, divide them into 3 equal portion of time. Yan. So, yun na yung magkakaroon tayo ng minimum, medium, and maximum. So, yan yung example. The minimum, medium, and the maximum. For example, we have here the presyon mayor, 6 years, 1 day to 20 years. So, i-divide natin yan para makuha natin yung minimum, medium, and maximum. So, the minimum is 6 years, 1 day to 8 years. Okay? The medium is 8 years, 1 day to 10 years. The maximum will be 10 years, 1 day to 12 years. Yun ang pag-divide. Anyway, pinag-aralan nyo ito sa correction nyo noon. Okay? So, the minimum is 6 years, 1 day to 8 years. Use the maximum of the minimum period as the minimum of the medium period and add 1 day to distinguish from the minimum period. Ayun. So, the 8 years as the minimum, dagdagan natin ng 8 years, 1 day plus 2 years. So, ilan? 10. 8 plus 2, 10. So, 8 years, 1 day to 10 years. Yan. So, your medium is 8 years, 1 day to 10 years. Okay? For your maximum, okay, yung medium mo, yan, yung maximum ng medium is 10 years, dagdagan mo ng 1 day. Okay? Plus, yung 2. So, magiging 10 years, 1 day to 12 years. That will be your maximum. 10 years, 1 day to 12 years. So, ganon ang pagkuha ng minimum, medium, and maximum. Okay? Next, we have, so these are just only few of the examples. Computation of the different minimum and maximum. Okay? Yan. Okay, in the imposition of fines, the court will fix the amount based on the mitigating and aggravating circumstance, the penalty plus the aggravating and mitigating circumstance. And not only that, they should also consider the wealth or the means of the culprit. The wealth and the means of the culprit. Okay, yan, in the imposition of fine. Okay, in the imposition of fine, they will consider the means and the wealth of the culprit. Penalty to be imposed when not all the requisite of exemption of the 4th circumstances. Yan. Yung in times of accident. Okay? Doon sa exempting. When all the condition required in circumstances in accident, okay, under Article 12 of exempting circumstance, okay, are not present, the penalty of aristo mayor. Okay, so the penalty of aristo mayor in its maximum, okay, to the prison correctional in its minimum shall be imposed upon the culprit if he shall be found guilty of the grave felony. Pag grave felony yan, ang pwedeng ibigay sa kanya pag kulang yung elements is arresto mayor in its maximum period to prison correctional in its medium period. Pero pag yan ay less grave felony naman, okay, if that is less grave felony, they will give the penalty of, okay, arresto mayor in its minimum and medium period. Arresto mayor in its minimum and medium period. Yan, in case of hindi kumpleto yung elements ng accident. Penalty to be imposed upon person under 18 years of age, 1 degree lower. Okay, 1 degree lower. Yan. So, 1 degree lower. So, ito, napalitan na ito. Okay, this is now a 1 degree lower under RA 9344. 1 degree RA 9344. Next, penalty to be imposed when the crime committed is not wholly excusable. Incomplete, justifying. Yan, kung incomplete justifying, pwedeng 1 or 2 degrees ang pagbaba ng parusa. Okay? 1 or 2 degrees ang pagbaba. Yun, yung sinabi natin kanina in exempting and incomplete exempting and mitigating. This is part of the, incomplete justifying and exempting pala. Incomplete justifying and exempting. This is now the application of the mitigating, paragraph number 1. Yung incomplete justifying and mitigating. Pwedeng bumaba siya ng 1 or 2 degrees lower. Yan. Next, successive service of sentence. When the culprit has to serve 2 or more penalties, he shall serve them simultaneously. Okay, he shall serve them simultaneously if the nature of the penalties will so permit. Okay? Otherwise, the rule shall be observed. So, pwede niyang iserve ng sabayan. If the imposition of the penalties, the order of the respective severity shall be followed to that there be executed successively, or as nearly as may be possible, should the pardon have been granted as to the penalty or penalties first imposed, or should they have been served out. So, in other words, in this first rule, ang dapat daw na unang iserve niya ay yung what? Okay? Respective, depending on there, yung pinaka-severe. Okay? Respective severity shall be followed. Kung mayroon siyang reclusion temporal, mayroong prison mayor, prison correctional, ang mauuna niyang iserve ay yung reclusion temporal. Kasi yun yung severe, most severe. Okay? So, when it comes to severity, mas severe yung, ayan, death, perpetua, temporal, prison mayor, correctional, arresto mayor, arresto minor, dischero. Pero when it comes to severity, mas severe ang arresto minor kaysa dischero. Kahit ang arresto minor ay 1 day to 1 month lang, while ang dischero is umaabot ng 6 months. Okay? Depending upon the discretion of the court. Pero mas severe pa rin ang arresto minor kasi nga it involved imprisonment. Okay? So yan, death, reclusion perpetua, temporal, prison mayor, prison correctional, arresto mayor, arresto minor, dischero. So, yan. According to severity, mas severe ang arresto minor kaysa sa dischero. Okay? Kasi this involves imprisonment. Yan. Susunod na lang yung mga accessory penalties. Next, we have graduated scale. Okay. The rule is, the lower or higher penalty shall be taken for graduated scale in which comprise the given penalty. Yan, the court. So, yan. Death, reclusion perpetua. Yan. So, yan yung pagbaba. Pwede kang bumaba dito, back, o kaya dito, or dito, applying the different rules. Yan. Yun. Pwede ka ring tumaas. Okay? You can go up. Yan. So, pwede kang umakyat din. So, yan yung pag-taas niya, no? Okay. So, that is in the application of aggravating and mitigating. Anyway, yan yung scale. Okay? As to the lower and higher penalty. Okay? Yan. So, pwede kang makyat doon. Bumaba. Yan. Okay? Scale. So, ito naman yung sa scale ng accessory penalty. Ano? Yan. Perpetual absolute disqualification, temporary absolute disqualification, suspension, okay, public seizure, fine. Next, we have preference in the payment of civil liabilities. The civil liability of a person found guilty of two or more offense shall be satisfied by following the chronological order of the date of the judgment rendered against him, beginning with the first in order of time. Pag magbabayad naman ng civil liability, okay, ang uunahing bayaran ay yung first na desisyonan. Okay? First in order of time, hindi yung pinakamalaki. Pag magre-render ng parusa, yung pinaka-severe. Pero pag yung civil liability, yung unang idiniklarang, yung unang judgment kung saan siya nagkasalaan na meron siyang kung saan meron siyang kasalanang civil or civil liability. Okay, the first in order of time. Okay, yan. Next, presumption in regard to imposition of accessory. So, accessory lang naman yan. It is implied. Sabi ko nga kanina. Okay, it is presumption. Okay, there is presumption. Okay, that there is an accessory penalty once a principal penalty is given. Next, penalty higher than reclusion perpetua. The penalty higher than reclusion perpetua is in cases in which the law prescribe a penalty higher than another given penalty without especially designating the name of the former, if such higher penalty shall be that death, the same penalty of accessory penalty shall be considered as to the next higher penalty. So the penalty higher than reclusion perpetua is death. Penalty higher than reclusion perpetua is death. Okay, next. Increasing or reducing the penalty of fine by one or more degrees. Whenever it may be necessary to increase or reduce the penalty of fine by one or more degrees, it shall be increased or reduced respectively for each degree by 1/4 of the maximum amount prescribed by law. Okay, so the pag-increase, yung pag-increase is by degree. So mas mataas na naman yung degree, i-increasean siya ng 1/4. 1/4 of the maximum amount. Anyway, yung court na ang mag-a-apply niyan. Okay? So, under this rule, maximum reduced by 1/4 if you get the lower degree. Legal period of duration of divisible penalty. The legal period of duration of divisible penalty shall be considered as divided into 3. Yun nga, sinabi natin kanina. We have there the minimum, the medium, and the maximum. Okay, yan. When the penalty is complex, one composed of 3 distinct penalties, in cases in which the law prescribe a penalty composed of 3 distinct penalties, each one shall form a period. The lightest of them shall be the minimum of the next, the medium, and the most severe is the maximum. So, dapat alam natin yung minimum, medium, and maximum. Ganyan lang naman yan. Okay? Yan. Next. When and how a penalty executed. No penalty shall be executed except by virtue of final judgment. So, saka mo lang i-execute yung penalty pag mayroon ng final judgment. Diniscuss na natin sa previous na ang counting or computation starts from the final judgment. Yung na-serve mo noon, ibabawas yon depending upon whether that is full time or forfeit. Okay? Remember yung detainees manifestation saka waiver of manifestation kanina? If you agree or not agree with the rules of the correctional institution. Okay? A penalty shall not execute in any other form than the prescribed by law, nor with other circumstances or incident than those expressly authorized by them. In addition to the provision of law, the special regulation prescribed for the government of the institutions in which the penalty are to be suffered shall be observed with regard to the character of the work to be performed and the time of its performance and other incident connected therewith, the relationship of the convict among themselves and other person, the relief which they may receive, and their diet. This is now covered by kung saan kulungan siya dapat ikulong. We have there the prison or jail, kung saan siya dapat ilagay. Okay? The regulation shall make provision of separation of sexes in different institutions. So mayroon tayong panglalaki, mayroon tayong pambabae, mayroon tayong pambata, mayroon tayong pangmatanda. Ganun lang 'yon. Suspension of the execution of service of penalties in case of insanity, Article 79. Okay, when a convict shall become insane or imbecile after final judgment has been pronounced, there will be the suspension. Okay, pag mayroon na siyang final judgment tapos nabaliw, suspended ang service of sentence. So dadalhin siya sa mental hospital. Suspended. Stop muna ang counting ng service niya pag siya'y nabaliw. Tutuloy ulit pag naging okay na siya. Okay, if at any time the convict shall recover his reason, his sentence shall be executed unless the penalty shall have prescribed. So itutuloy niya unless nag-prescribe na yung penalty. Okay? Yan, the respective provision of this section shall also be observed if the insanity or imbecility occurs while the convict is serving his sentence. When and how the penalty is to be executed. So, the death sentence shall be executed with reference to other and shall consist in putting the person under sentence to death by electrocution. Okay, but I want to clarify this. This is under the revised penal code. But right now, we have now lethal. Okay, ang ginagamit na natin ay lethal injection. So, we are now using the lethal injection na po tayo. Okay, there is a, by virtue of a law. Okay, the lethal injection law of the Philippines in 1996. Okay, the RA, okay, that is the RA 81, RA 8177. That is our lethal injection law, from electrocution to lethal injection. Okay. If the person under sentence so desire, he shall be unstated at the moment of the electrocution. Wala na ito, so lampasan na lang natin. So, next, wala na rin to kasi wala naman ng death penalty. Yan. Okay. So, then, to suspension of execution of death penalty. Yan, the death sentence shall not be inflicted upon woman within 3 years. So, daanan lang natin, hindi pwedeng isentence sa death penalty ang babae within 3 years. Okay. Upon woman within 3 years following the date of sentence or while she is pregnant. Okay, so 3 years. Hindi pwedeng i-execute ang death penalty sa babae following the date of the sentence. So, pag nasintensyahan siya ngayon, after 3 years, saka pa lang pwedeng i-execute. Tapos, pag siya ay buntis, okay, if the woman is pregnant, hindi rin pwede within 3 years. Nor upon any person over 70 years of age. Hindi rin pwede. 70 years of age. In this last case, the death sentence shall be commuted. So, i-commute siya. So, magkakaroon ng commutation pag matanda na. Pag more than 70 years old. Okay, so yan. Yung suspension. Suspended ang execution. Okay, next, place an execution of person who witness the same. So, sa National Bilibid Prison. Okay, National Penitentiary, doon siya bibitayin sa death or sa room, sa lethal injection room. Yan. Okay, sino ang nandoon? Okay, the priest or the minister, the lawyer, his relatives. Okay, not exceeding 6 ang relatives. Yan. She can also have the physician, okay, of the penal establishment, and by such person as the director of prison may authorize. But usually, the priest, the lawyer, then the physician, and the relatives not exceeding 6. Provision relative to the corpse of the person executed to its burial. Okay, so hindi po pwedeng iparada. Unless claimed by his family, the corpse of the culprit shall upon completion of the legal proceedings subsequent to the execution be turned over to the Institute of Learning. Kung hindi i-claim ng pamilya, if the family will not claim it, ibibigay nila sa mga eskwelahan na kung saan mayroong medical school, institution for learning, for scientific research. Okay? First, applying for it for the purpose of study and investigation. Provided such institute shall take charge of the decent burial. Sila na rin ang magbabari sa remains. Okay? Otherwise, kung walang kukuha, the director of prison shall order the burial of the body of the culprit at government expense. Okay? To be present thereat to the member of the family and culprit. Next, reclusion perpetua, reclusion temporal, prisión mayor, prisión correccional, and arresto mayor. The penalties of reclusion perpetua, reclusion temporal, prisión mayor, prisión correccional, and arresto mayor shall be executed and served in places of penal establishment provided by the administrative code. Okay? In force or which may be provided by law in the future. So, this is covered by your penology. Ano? Kung yan ay 3 years or more, that will be in the prison. Okay? Under yan under yan ng Bureau of Correction. If the penalty is 3 years and below, that will be under the different jails, under the DILG or VGMP, and if that is government provincial prisoner, he will be under the provincial government. So yun, maliwanag na yun sa atin. Distiero, yan ang distiero. Any person sentenced of distieros are not permitted to enter the place or places designated in the sentence within the radius specified therein, which shall not, okay, not more than 200 and not less than 25 kilometers from the place designated. Okay, so not more than 250 and not less than 25 kilometers from the place designated. That is distiero. Okay. Arresto minor, the penalty of arresto minor shall serve in the municipal jail. Okay? Municipal jail pag arresto minor. Or in the house of the dependent himself, kasi 1 day to 30 days under the surveillance of the officer of law. So, pwede ito recognizance. Yun, in connection to your correction, pwede siya sa recognizance. Or sa municipal jail. How criminal liability extinguished? There are 7 ways. Total extinction, ang pinag-usapan natin dito. So, total extinction of criminal liability. Number 1, death of the convict. The death of the convict, yan. After the death, we have the service of sentence. Yan, the service of sentence. Pag namatay yung convict, wala na siyang criminal liability. Ano? Pag na-serve niya na yung sentence niya, wala na rin siyang criminal liability. Pag na-serve niya na yung sentence niya, tapos na na-serve mo na. Okay? By absolute pardon. Okay? Pinardon ka ng president, absolute pardon, wala na. You're free like a bird. Okay? We have also amnesty. Group pardon. It's also total extinction. Okay? Another, prescription of crime. Nag-expire na yung pagpa-file ng kaso. Okay? The state loses the right to prosecute. Prescription of crime is the forfeiture of the right of the state to prosecute the offender under the lapse of certain time. Nag-expired na yung pagpa-file ng kaso. Then we have the prescription of penalty. The prescription of penalty, okay, the forfeiture of the right of the government to execute final sentence after the lapse of certain time. And the last is by marriage. Marriage of the offended woman. In times of rape, mga yan, another article 344 of this code. So, prescription of crime. Nag-expire ang kaso. Sir, kailan? For the crime of death. Okay? Reclusion perpetua. Reclusion temporal. Nag-prescribe yan 20 years. Okay? Expiration ng death, perpetua and temporal, 20 years. Expiration ng other afflictive penalties, ito yung tinatawag nating presyon mayor. Siya na lang ang natitira sa afflictive penalties. Tatlo lang naman ang afflictive penalties natin. Perpetua, temporal, and presyon mayor. Death is not afflictive. Death is capital punishment. So, pag presyon mayor, prescribe siya in 15 years. Expire siya within 15 years. After 15 years, rather. So, next, those punishable by correctional penalty. Presyon correctional, aresto mayor. Okay? Presyon correctional. Ang presyon correctional, ang prescription niya ay 10 years. Ang aresto mayor, ang prescription niya ay 5 years. So yan, tandaan natin yan. The crime of libel and similar offense, the prescription is 1 year. A crime of libel is 1 year. Okay, the crime of oral defamation and slander by deeds, prescribed in 6 months. Oral defamation, slander by deeds, prescribed, expire 6 months. Light offenses, prescribed or expire in, light offenses, prescribed or expire in 2 months. Yan. Okay, when the penalty fixed by law is compound 1, the highest penalty shall be made the basis. Kung compound ang penalty, so the highest penalty shall made the basis of the application of the prescription of crime. Okay? Next, we have the computation of prescription of offense. Paano start yung computation ng prescription of penalty of offense or prescription of crime? The period of prescription shall commence to run, ito, from the day on which the crime was discovered. Yan, by the offended party. Okay, from the day on which the crime is discovered by the offended party, yan ang computation of start ng computation of penalty. The offended party, the authorities, or their agent. Yan, that will be the start of the computation of prescription of penalty. Yan, and shall be interrupted on the filing of information. Sinabi natin yan noon sa procedure that the filing of complaint or information will interrupt the commencement of the prescription of or the prescription of crime. Okay? Next, we have, so the term of prescription shall not run when the offended is absent from the Philippine Archipelago. Pag nasa abroad siya, okay, so hindi siya tutuloy yung counting. Tutuloy ulit pag bumalik na siya ulit dito sa Pilipinas. Next, we have when and how penalties prescribed. Prescription of penalty naman to. Okay? Kailan naman nag-expire ang penalty? Yan. If death and reclusion perpetua, 20 years. Anong na-observe mo dito? Wala na yung temporal. Hindi kagaya kanina sa prescription of crime, nakasama sa 20 years yung temporal. Pero dito sa penalty, dalawa lang. Death and reclusion perpetua, 20 years. Okay, other afflictive penalties, Kasama na dito yung reclusion temporal at saka prisyon mayor. Okay, reclusion temporal at saka prisyon mayor, sila ay magpre-prescribe within or prescribe in 15 years. Okay? We have correctional penalties, 10 years. Gaya rin kanina. Correctional penalties, prison correctional, 10 years. Aristo mayor, 5 years. Aristo mayor, 5 years. Light penalties, 1 year ang prescription of penalty niya. Okay? Yan. So that is now the prescription of penalty. Computation of the prescription of penalty. Kailan siya nagsisimula? From the date the culprit evade the service of sentence. Okay? From the date the culprit evade the service of sentence. Mula nung siya'y nakatakas or siya'y tumakas. Yan. Okay? So, it will stop if he is at the foreign country. Ano? Pag nasa labas naman siya, hindi siya mag-expire. Okay? Pag nasa labas siya ng bansa, stop din ang counting. Gaya rin kanina. So, yan. Partial extinction. O yung sinabi nating 7, total extinction. Ito naman, partial. Partial extinction of criminal liability. We have conditional pardon. Yan. It depends upon the agreement in the conditional pardon. We have commutation of sentence. Commutation pag ang parusa ay pag ang offender ay 70 years or more, more than 70 years old. So i-commute, i-reduce yung penalty niya. And we have the GCTA or good conduct time allowance. Okay? Yan. Conditional pardon is a contract between sovereign power and the convict. So it's a matter of contract ang conditional pardon. Yan. Commutation, change the decision of the court. Okay, regarding the degree of penalty. Yan naman yung commutation. Yan. And we have there we have also parole. So we have good conduct time allowance. Mamaya pag-aralan natin yan. Okay. So we are in Article 95. Obligation incurred by person granted conditional pardon. Yan. So, any person who has been granted conditional pardon shall incur the obligation of complying the condition. So, pag yan ay conditional pardon, you must comply with the condition. Yan. Imposed therein, otherwise, his non-compliance with any condition specified shall result to the provocation of provision. And Article 159 shall be applied to him, or the violation of Article 159. Okay? Next, effect of commutation of the original sentence from a different length and nature shall have legal effect, substituting the later in the place of the former. So, ang mangigibabaw dito sa commutation ay yung bago. Okay, yung ipinalit. Usually, ginagawa yan if the person is more than 70 years old. Allowance for good conduct time allowance, okay, shall have the following deduction. For first 2 years, we have of imprisonment, we have 5 days per month. Okay? For the 3rd to 5th year, we have 8 days. Okay? 8 days per month. For 6 to 10 years. Okay? 6 to 10 years, we have 10 days each month. And more than 10 or the 11th or more, 15 days. Okay, 15 days each month. So yan yung rule under Article 97. But it was amended by Republic Act 10592. Okay? 10.5. So, ito na ngayon, under RA 10.592. So, from 5 days a month, ginawang 20 days a month for the first 1 and 2 years. Pag granted ang good conduct time mo. Pag 3 to 5 years, kay dati 8 days per month, ginawang 23 days per month. So, napakalaki. Okay? Yung 6 to 10 years, dati ay 10 days per month, ginawang 25 days. Okay? Ginawang 25 days. Now, yung 11 or more years, dati is 15 days, ginawang 30 days. Yan yung RA 10592 or the what you call the good conduct time allowance. Okay, now, we have also special time. Aside from that, sa good conduct time allowance, meron pa yung tinatawag na STEM. Pinag-aralan din natin ito sa correction ninyo. Yung student-teacher mentoring. May additional ka bang 15 days doon, di ba? So, yun. So, we already discussed this new law on Republic Act 10592. Next, we have also a special time allowance for loyalty, a deduction of 1/5 of the original sentence will be given to a prisoner, okay, who give himself to the authorities within 48 hours following the issuance of proclamation announcing the passing away of calamity or catastrophe in the said article. Yan, special time allowance for loyalty. So, 1/5 of the original sentence ang may dadagdag. Kung may calamity, lumabas ka, okay, nagka-earthquake, nagka-typhoon, lumabas ka, then bumalik ka after the announcement of the calamity. So, you give yourself to the authorities within 48 hours after the proclamation of passing away of the calamity, mababawasan ka ng 1/5. Sir, paano pag hindi bumalik? Okay, ang bawas sa'yo, pag bumalik ka, 1/5 of your original sentence. Pag hindi ka bumalik, madadagdagan ka ng 1/5 of your remaining sentence. 1/5 of your remaining sentence. Okay? Yan. Pero pag hindi ka bumalik, hindi ka umalis. Pag hindi ka umalis, you will be deducted 2/5 of your sentence. Mababawasan ka ng 2/5. Malaki yun. Okay? Pag hindi ka umalis, inantay mo na lang doon ka lang sa loob, you will be given 2/5 deduction. 2/5 deduction. Okay? 2/5 deductions. Next, who grants time allowances and good conduct time or special time allowance are being given by the Director of Prison. Okay? The Director of Prison, yan. The Bucor, Director of Prison or the Bucor. Yan. The Director General of the Bureau of Correction. Kung sa BGMP naman, the warden gives you the good conduct time allowance or special time allowance for loyalty. Yan. Okay? Next, we have the civil liability. Tapos na tayo sa criminal liability. Let's proceed to civil liability. So, civil liability of a person guilty, tandaan nyo to, every person criminally liable is also civilly liable. Yan. Ang taong may kasalanang kriminal ay mayroon din niya siyang civil liability. Yan. So, every person criminally liable for a felony is also civilly liable. Okay, that is the rule under Article 100. Next, we have 101, rules regarding civil liability. The exemption from criminal liability extinguished, okay, does not exclude exemption from criminal liability. Under your justifying and exempting, kahit na ikaw ay yung sa justifying, exempted ka sa civil liability. Sa exempting, sa Article 12, sa exempting, exempted ka sa sa civil liability but not in criminal liability. While in Article 11, yung justifying, exempted ka sa criminal liability pero hindi sa pati sa civil liability. Okay, repeat. In justifying, exempted ka sa criminal liability at saka sa civil liability, except in paragraph number 4. In exempting, exempted ka sa criminal liability pero hindi sa civil liability. Yan. Okay? So, that is now the rule under Article 101. Should there be no person having such insane, imbecile, or minor under his authority, legal guardianship, or control, or if such person be insolvent, said insane, imbecile, or minor shall respond to their own property, exempting property exempt from execution in accordance with the civil law. Yan. So, bayaran nila using their property. That is Rule 101. Now, Rule 102, subsidiary liability of innkeepers, tavern keepers, and proprietors of establishment. Yan, yung may-ari ng hotel, pag nawalan ka doon, na-declare mong nawala, pwede. Bayaran nila yon. Yung sa aeroplano, pag dineclare mo, tapos nawala doon, bayaran nila doon. Yan, so, yan, subsidiary liability of innkeepers, tavern keepers, and proprietors of establishment. Okay, even sa SM, pag nawala yung gamit mo at diniposito mo doon sa kanilang baggage area, then they are still liable for that. Okay. Next, we have the subsidiary liability of other persons. Subsidiary liability, if established in the next proceeding, shall also apply to employers, teachers, person, and corporation engaged in any kind of industry for felonies committed by their servant, pupils, workmen, apprentice, or employees. Halimbawa, mayroon kang tricycle or jeep, ikaw ang owner, pero iba yung nagdadrive, yung tauhan mo. Pag na-aksidente yon at hindi siya makabayad, you as the owner is also subsidiary liable. Ikaw ay teacher, bis na binabantayan mo yung bata, lumabas, tapos nakagawa ng kasalanan doon, and incurred civil liability, you as the teacher are liable. Okay? Yan. Even yung mga trabahador mo. Okay? You're the architect. Tapos, may pinagawa ka and it creates now mayroong na violate na rights. So, you are also liable for that kung walang negligent yung kasama mo, yung mga tao mo. Like your drivers, ganun. Okay? And even corporations. You are subsidiary liable. Okay, next we have another article. Okay, ano yung civil liability? Ano yung mga civil liability? We have restitution, reparation, and indemnification. So, restitution, reparation, and indemnification. Okay? So, yan. So, restitution, yan yung ibalik mo. Yung talagang kinuha mo. Reparation, ayusin mo. Indemnification, kung wala na, is bayaran mo pati yung mga consequential damages. Okay, kung yung nasira mo, may gamit, halimbawa yung sasakyan, hindi nakapagbiyahe, bayaran mo na yon, yung kita ng sasakyan. Yun yung indemnification. Okay, so yan. Restitution, the restitution of thing among itself must be made whenever possible with allowance to any deterioration or diminution of value as determined by the court. Yan. So, ibigay mo yung kinuha mo. Halimbawa, kinuha mo yung sasakyan, ibalik mo. That's restitution. Restore. Yan. The thing itself shall be restitution. Reparation. The court shall determine the amount of damage taking into consideration the price of the thing. Kung hindi na maibalik, bayaran mo na lang. Kung nasira, ipaayos mo. Yan. Reparation yon. Pero pag hindi na maibalik, bayaran mo yung value. Okay, that is reparation. Pati yung sentimental value. Next, we have the indemnification or for consequential damage. Okay, shall not only those caused the injury but also those suffered by the family and third person. That is indemnification. Yan, mga naging epekto. Bayaran mo rin. Mga medical services. Okay, mga pampa-hospital, mga ganyan. So, these are indemnification. Even the burial, mga ganyan. Okay. Next, obligation to make restitution, reparation for damages or indemnification for consequential damages Okay, an action to demand the same upon whom it devolved, the obligation to make restoration or reparation for damage or indemnification devolved upon the heirs of the person liable. So, saan kukunin? Halimbawa, namatay na yung taong liable. Okay, so kukunin siya sa heirs. Okay, kasi yun sa mga naiwang ari-arian niya. The action to demand restitution likewise descend to the heirs of the person injured. Yan. So, ang may karapatang kolekta ay yung mga heirs ng na-injured na tao. Ang kukolektahin, kung namatay na rin yung nang-injured, the heirs of the person liable. Okay, next, share of each person civil liable. If there are two or more persons civil liable for a felony, the court shall determine the amount which each must respond. O di pagkatiyan nila kung ilan sila. Yan, yung share of each person civilly liable. Okay? Kung siya ay principal, accomplice, accessory, may kanya-kanyang sharing yan. Okay? Civil and subsidiary liability of principal, accomplice, and accessory. Ito na yon. Okay? So, the subsidiary liability, notwithstanding the provision of the next presiding article, the principal, accomplice, and accessory, each within their respective class, shall be liable severally among themselves for their quotas, and subsidiary for those of other penalties liable. Subsidiary liability shall be enforced first against the property of the principal, next against the property of the accomplice, and next against the accessory. Ganun yun. So, tatlo kayo. Yan, kung magkano ang babayaran. Okay? So, halimbawa, pag 100,000, pwedeng hatiin nyo. Yung half will be sa principal, siguro yung accomplice will be, sabihin natin kung mayroong 100, tapos yung principal 50, yung accomplice ay sabihin nating 75%, 37.5. So, magiging 37,000 din siya. Tapos yung 22,500 ay sa accessory. Ganun yun. So, you have your own levels. Obligation to make restitution in certain cases. Any person who has participated gratuitously in proceed of a penalty shall be bound to make restitution in an amount equivalent to the extent of such participation. Kung ilan ang nakuha niya, yun lang ang ibabalik niya. Kung nakinabang siya doon. Okay. Next, we have extinction of civil liability. Yan. Pag binayaran mo na, nawala na, loss of the things due, then condonation, sinabing hindi mo na babayaran, confusion or merger, parang i-share mo na lang yon. Okay, confusion or merger of the rights of the creditor and debtor, ibawas mo na lang sa yung confusion, parang merger, parang magiging part ka na nila. Yan, nag-merge na kayo, so mawawala na yung utang mo. Then, compensation, yung compensation naman, i-compensate na lang, which may utang ka sa akin, may utang ako sa'yo, let's compensate, o yun. And novation. Novation yung pinabayaan na lang. Okay? Then, wala na. Sa tagal na ng panahon, hindi ka na pwedeng singilin. Yan. So, these are the extinction of civil liability. And we have the obligation to satisfy civil liability. Yan. So, except in case of extinction of civil liability as provided in the next presiding article, the offender shall continue to be obliged to satisfy the civil liability resulting from the crime committed by him, notwithstanding the fact that he has served his sentence. Kailangan niya pa rin bayaran kahit na-serve niya na yung sentence niya. Okay? So, yan. So, that is all for Article Criminal Law Book 1, Article 1 to Article 113. Medyo mahaba, so we have this kind of session. Okay, so thank you and see you again in the next session. Yan.